Outa deliberately did not comply with Section 1571D to seek leave of the court. Why? Because Section 1571D would have required Outa to state the following: that Outa, in the public interest, is entitled to the relief that is granted under Section 162. They do not do that. They plead it as a one-liner in the particulars of claimant to say, wherefore leave of the court is sought. And they do not come through the certification process because they wouldn't have made it through that door, which are the two pillars of our application to say, one, they do not act in the public interest. Two, the relief that they seek cannot be granted in the public interest. The Companies Act does not provide for that. And I will get to the point about well, my lady, as per your previous ruling, the special plea of standing has always been there. No.
Immediately proceed to the special plea. Ms. Steinberg? I'm just going to inquire from her, and then you will also know what to do.
Lady, our submission is that because the amendment application was refused, the applicant here is confined to the initial special plea. And we accept that he first said he wouldn't pursue it, now he says he will, and he's welcome to. However,
the rest of your argument I will hear later. I just want clarification on that point.
But, my lady, with the court's leave, a learned friend is arguing as if his amendment were granted, and his amendment weren't granted. What stands is the special plea, and I was going to object anyway before my lady invited me to speak on a related point. The special plea...
But isn't it then better? He knows your view point at this point in time. Just for practical purpose, if Mr. Buthelezi deals with his whole argument, and then you can deal with yours, and then I will decide the issue either one way or the other. Just for practical purposes, I think it will be a more conducive hearing. Otherwise, we will have to stand down. I will have to write a judgment about this. It may delay the proceedings. So, from a practical point of view, if Mr. Buthelezi knows what he's facing, then he can deal with that. And I was just concerned that there might be a misunderstanding at this point in this regard.
No, my lady, we certainly don't object to him withdrawing his initial withdrawal.
Yes.
What we object to is him going beyond his pleadings.
Well, but then I'm going to allow you to argue that when it's your turn. Thank you, Mr. Buthelezi. At least now I also have that clarification. Sorry for interrupting you. You may proceed.
What was pleaded, my lady, was that they did not obtain leave of the court. And we say 1571D says may act in the public interest with leave of the court. They've deliberately not sought the leave of the court. And they want to pursue the route that says leave of the court may be granted after the fact if the court is satisfied on the papers that a case has been made out. It's deliberate, my lady. It's to overcome this hurdle that they face with regards to 162, because they would have had to, in making that application, make the averment that they are entitled to the relief under Section 162, which the statutes do not provide for. And they want to short-circuit the process of having to go through the leave of the court and come through a side entrance and infer standing through that process. Now, in as much as I'm confined to the plea, the point remains that the court could have never granted its leave because the relief which they seek is not competent with regards to what may be exercised in the public interest. So the points as I've made them remain, my lady, and I will give reasons as to why the court cannot grant the relief that they seek. Now, the starting point is here. In the case Lawyers for Human Rights versus Minister of Home Affairs and another, it's the first citation, my lady, 2004 4 SA 125 Constitutional Court. It says a distinction must be made between the subjective position of the person or organization claiming to act in the public interest on the one hand, or whether it is, objectively speaking, in the public interest for particular proceedings to be brought. So that's where their first issues occur. Can we, from what they've alleged, infer public interest? We say not. And we rely on the US authority of Frothingham versus Mellon, Secretary of Treasury, where it states that Mrs. Frothingham had an abstract interest in the way in which public revenues were appropriated, and further held that it would not be tenable to contend that every taxpayer had a right to challenge a law as unconstitutional because its enforcement required expenditure of public money. We say in this application or this action by Outa is in the abstract. Why? Look at the substantive contents of the case. They speak about the Ernst & Young report. The board did not implement that report. Whose rights are being affected there? What's the public interest there? 2, they speak of the Emirates deal that did not happen. For whatever reasons, it didn't happen. Whose rights are being affected there? There's a speculative amount that the company potentially lost earning certain money. It's in the negative. It's money that could have been potentially lost. Same thing, Pembroke Airbus deal. There's a dispute over whether SAA should have bought 10 aeroplanes or should have bought 2, and how it should have been financed. Where is the public interest in the substantive content? Whose rights are being affected? If we go towards BNP Capital, the issue is about the payment or non-payment of a cancellation fee that was never paid. So how then, in any of these issues, is the public affected?
But seeing that we're dealing with our national carrier,
Yes.
is that not in the public interest? That does the public not have an interest in the financial well-being of the South African Airways?
Well, that may be, my lady, but the legislation doesn't allow 162 to be applied in the public interest. It's not there. And I will get to the point about why 162 cannot be applied in the public interest and what 157 actually applies to, and where 1571D is applicable. And the third point is that it cannot be where a party like the South African Pilots Association is founded standing under Section 162. What purpose does Outa's presence serve? The Pilots Association has got the proper standing in law to bring this application. Why does Outa come and crowd the court? There's no basis, because in the end of my submission, my lady, I'll make the submission as to how 1571D should have been implemented and how it's not been. So, firstly, is that in citing Lawyers for Human Rights versus Minister of Home Affairs, it says, it is not in the public interest for proceedings to be brought in the abstract. And we say in this particular case here, Outa's position is bringing a case in the abstract, because the point that you make, my lady, with regards to taxpayers, our national carrier, that is in the abstract. When we seek into the space of public interest, there's got to be rights of certain persons being affected. This is now what the courts define as abstract. At paragraph 16 of the particulars of claim, this is what Outa says. It says, Outa's interest in the public interest arises out of Outa's primary objectives. These include the protection and advancements of the Constitution, as well as the promotion and effective practical enforcement of taxation policies which are free from corruption, and a proper management of public entities. All rhetoric. It's all this political rhetoric. But when we come to the court, in terms of what the court will qualify as public interest, the hurdle is much higher. There may be a media interest, there may be a public interest, but the case law is there, and we'll get to it, in terms of establishing what constitutes public interest. And I make the point to say, paragraph 16 speaks nothing about rights that are being infringed. It speaks nothing about the vulnerability of people that are being affected. And it speaks nothing about the consequences of an infringement. So the test is set out in Ferreira versus Levin, where to establish public interest, there are criteria set out in the leading authority where it says that there was a reasonable and effective manner in which the challenge could be brought. We say yes, there is. The reasonable manner in which the challenge could be brought was to approach anybody withstanding under 162 and say certain circumstances exist for you to then implement or to seek enforcement of the rights afforded to you under 162. That's the first point. The second point, the nature of the relief and the extent to which it was of general application. What is of general application in having the second or the first defendant being declared a delinquent? Who benefits from that? 2 years, 3 years down the line since she's not in office anymore. Of what benefit does it benefit? Anyone. More so, it now seeks to go further. If you are declared a delinquent director, you cannot be a director in your own company or any other company. How does the public stand to benefit in somebody not making a living for themselves? I think it's most absurd. And then it says nothing about who stands to benefit or who stands to lose in so and so being declared or not being declared a delinquent director. So the principles of Ferreira versus Levin are very clear. However, they contend that they meet the standard, and I think that will be for them to convince the court on that. What we say is that this particular action and the issues that are being discussed here do not raise a public interest issue. Because there's a broad allegation to say there's violations of the PFMA and this conduct led to breaches of the PFMA. There's no finding to that effect that there actually has been a violation of the PFMA. It's an untested allegation at that point. And we say that Section 52B and Section 81 of the PFMA provide for the public interest. And it says, Section 55(2)B, the annual reports and financial statements must include A1, any material losses through criminal conduct or irregular expenditure and fruitless and wasteful expenditure that occurred during the financial year. 2, any criminal or disciplinary steps taken as a consequence of such losses or irregular expenditure. Or 3, any losses recorded or written off. In other words, what does this tell us? All public entities or state-owned enterprises which are confined to reports in line with the PFMA have to make these disclosures in the public interest. It's there. So, for this to have written up as a PFMA violation, it needs to be reported as such first in the SAA financial reports. And only then does the issue of triggering of the PFMA kick in, or violation of the PFMA kick in. It hasn't triggered that point at this stage. And they cannot come trigger it through the courts to make the courts to say there's been a violation of the PFMA. And it's very broad. It doesn't say there needs to be a finding. It says there needs to be an investigation. There needs to be charges. It doesn't confine it to a finding. Or whatever process that the organization is undergoing to deal with alleged breaches of the PFMA, you need to report it in your financial statement. It's not there. So the basis from which they depart from in alleging PFMA violations is flawed. True. Section 85(1) states the following. The minister must make regulations prescribing A, the manner, form, or circumstances in which allegations and disciplinary charges of financial misconduct must be reported to the National Treasury, the relevant provincial treasury, and Auditor General, including 1. Particulars of alleged financial misconduct. 2. Steps taken in connection with such financial misconduct. Makes the same points again. The minister is empowered under Section 85(1) of the PFMA to make pronouncements about violations of the PFMA in the public interest. This has not happened. And we cite the case of Bailey and others versus Buchelo Outa and another, where paragraph states the following. It says, I am of the view that the reason for Section 55 and 85, read with regulations, was to expose officials who are found to be involved or allegedly in financial misconduct, such publication would be in the public interest.
But in the end, if they don't prove a case against her,
yes,
aren't you jumping the gun now? If we look at the question of public interest at this point in time, would it be appropriate for the court to consider these issues at this time? Certainly this court cannot do that.
My lady, what they've pleaded is violations of the PFMA.
Yes, but obviously they haven't proved it yet. That is the point of the whole case.
And that's what I say, my lady.
But certainly one cannot determine the standing and equate that with the actual onus of proof to prove your claim.
My lady, the point is different. The point is the following, is that you first got to establish whether what you allege constitutes public interest. And we are saying, at paragraph 14 of my head, is that untested allegations of violations of the PFMA cannot be used to allege public interest. We say you can allege public interest on the basis of findings of Section 55, 2B, and Section 85 of the PFMA. In other words, if there was already a report that says so and so has violated the PFMA, and the minister has taken actions in terms of 85(1), and I'm not saying, my lady, it's findings, it's even an investigation for the fact that it has been reported in accordance with the legislation. That is the point that triggers the allegations of violations of the PFMA. At this point, the allegations of violations of the PFMA are premature. They cannot be made in this instance.
Well, if I understand it correctly, they're saying we have an interest that if proven, if we can prove what is alleged, then the public's interest will be affected. Obviously, at this point, they haven't proven anything yet. But they want to approach the court at this point in time in order to test their allegations. Certainly, you can't expect them to prove their case in the special plea Maybe I misunderstand you, Mr. Buthelezi.
I'll try to put it differently, my lady. They are alleging violations of the PFMA. And we are saying the allegations that you make about violations of the PFMA are not founded, because violations of the PFMA can only come through what is reported under Section 55 and Section 85.1. And there's an authority that confirms that, to say this is what the PFMA provides for, to be articulated in the public interest. So we say, even if I lose on this point of whether maybe the public interest does exist, however, they are not entitled to the relief they seek in the public interest. The legislation does not provide for that. And that is the basis upon which we say the court could have never granted the leave as prescribed by Section 1571D to say you must bring an application in the public interest with the court's leave. And it's a deliberate thing that the court would require, you would require the court's leave. Why? It's because the court must first ascertain those very 2 points. Are you coming legitimately in the public interest? 2, are you entitled to the relief that you seek? And they bypass that process completely. They bypass the process of what is prescribed in the legislation to establish those 2 grounds to give you standing. And we are certain they could have never made the case out. They could have perhaps succeeded in making a case out for public interest, but they could never make the case out to say they are entitled to the relief as granted under Section 162. And on that basis, the leave of the court would have never been granted. We still argue that in the initial plea, the initial special plea, even in the one that hasn't come through in the amended special plea, the point remains. The court could have never granted this leave, because the court would have had to interrogate that very simple point. Are you entitled to the relief that you seek? The answer is a flat no. And I'll get to the reasons why. Well, it's in their argument where they say, we emphasize, Outa says the following, that for purposes of assessing standing, it must be assumed that Outa's allegations of Mrs. Myeni's wrongdoing are correct. And this, we say, my lady, this is just inviting the court to violate the Constitution, because now it breaches the principles of presumption of innocence and the rights protected under Section 34. How can Outa ask the court to say, to give us standing, please assume that we are right and this person is wrong? The presumption of innocence is not only something applicable in the criminal standard, it applies in civil matters as well.
No, but we're not even remotely there, whether the case has been proven against the applicant on a balance of probabilities.
Well, my lady, I'm dealing with the point that is Outa's submission in seeking this standing. They say, after making the allegations about PFMA violations, they take it to the next step, where they say the following. We make these allegations, and we ask the court to accept them as correct. And that's the point I'm telling you, to say, well, make your allegations, it's fine. But to then ask the court, in the circumstance, to say, when considering our standing, may the court presume that what we say is right and what you are saying is wrong. And I'm saying that is erroneous in law, my lady. The court cannot be asked to do that. And more so, we get to this point. It's no accident that we have the Pilots Association here. Because they're Outa's backup plan. Because Outa knew from the outset that their standing was shaky. But to proceed with this thing, they need somebody with guaranteed standing.
They have the same legal representatives.
I'm saying the
So,
first...
say for example, I find in your favor, and I find that Outa does not have standing.
Yeah.
Then in any event, the procedures the matter will proceed just without Outa, with the
Yeah.
same legal team and the second plaintiff.
That is our prayer, man.
How is that going to assist? On a practical level, how is that going to assist the applicant, or let me rather call the defendant in this matter?
Two things, madam. We'll speak about ourselves and then we'll speak about the law. For us, it's great because then we can deal with one plaintiff versus two. Regardless that they are both represented by the same person, it's two plaintiffs. It's good for the court to have the right parties in court and not overburden the court unnecessarily. Nothing changes materially from the arguments or anything that they make, but the point is it will create a big problem going forward where the Companies Act does not allow for this application, 162, to be brought in the public interest. It's not there. The persons under 162 who are conferred with standing is a closed group. It's a closed group. And divided into two categories. First category is one, it's the company. In other words, where 162 standing is conferred is the company, shareholder, a director, company secretary, prescribed officer of the company, a registered trade union, which we have here, or other representative of employees of the company. Nobody acting in the public interest, not there. Two is the commission or panel, third, or any organ of state responsible for the administration of any legislation. Now, where does 162 come from? 162 comes from section 69, which talks to ineligibility and disqualification of directors. It is it's section 69 that is the founding section from which 162 stems from. Now, what is 69 and what is 162? 69 speaks to the principles that are applicable with regards to disqualification of directors and ineligibility to be a director. It's there, 69. And then 162 speaks to the procedure to be followed in executing a delinquency application. So, if you go back then to section 69, what do you find? The category of people who are entitled to the relief as specified in all the remedies under 69 is the same grouping. No provision for somebody to bring and seek this relief in the public interest. It's not there.
Mr. Buthelezi, but say for example, this court dismisses this special plea and say they have standing. It's still conceivable that at the end of the trial, the court might say that the first plaintiff is not entitled to the relief claimed under the Companies Act, and would therefore be, for example, be burdened with the costs for their presence. So
Yes.
I try to understand the purpose of this special plea, because it seems to me that even if you're right, and the court could still find in the end that as a result of the Companies Act and the application of the Companies Act, that the first plaintiff is not entitled to the relief, but the second plaintiff might be.
Indeed.
And then a cost order could be granted against the plaintiff. So should the court at this point in time deal with the question of the special plea, what is the advantage of dealing with that at this point in time? The same lawyers are still going to be here.
It's to avoid undesirable legal outcomes, my lady. It's to avoid undesirable legal outcomes to this extent.
But you know what? If the court in the end comes to any decision, you still have the possibility of an appeal. So we can't avoid legal outcomes at this point in time. So I just want to understand your vantage point.
My point is the following, my lady. Part of the proceedings that we do before starting trials, we engage in pre-trials, where we narrow down the issues, so that come trial stage, we are only dealing with only those issues that are in dispute. It is to burden the court unnecessarily with an entire trial where evidence and witnesses will be led.
But it will be the same witnesses, it will be the same evidence. In the end, it is a question of whether the first plaintiff will be entitled to the relief. And if the court finds they're not entitled to it, and their presence have occasioned costs, that there might be a cost order against them.
That as it may be, my lady, but we are saying we brought a joint application to get relevant parties into this case, and the court has pronounced itself on that point. In the same line, we are saying we need relevant parties in this point. How is it possible for people to engage in a frivolous exercise to the extent that they can run an entire trial where they've never had standing to begin with? And that's why it is a point in limine, whether they are in a pool facility of resources with the first and second plaintiffs, that's fine. But parties cannot come to the court and be unnecessary parties in the court. Parties cannot come to the court and hope to say the court will pronounce in the end whether we were entitled to be here or not. That is an issue that needs to be determining at the outset. Then we know we're dealing with one plaintiff, because in particular, for the one reason, one party is a trade union with standing, somebody else is a hanger-on. They're just latching on. I don't think the courts were designed for people to come just on vanity projects of this nature. We need to be all properly here before this court. And that's why we've got non-joinder, misjoinder, and all the other joinder procedures, is to ensure that parties appearing before the court are the correct parties. And it's not for subsequent determination once the merits have been determined. It's for upfront determination. The principles apply the same, whether it was one plaintiff or 10. We need to make sure that of the plaintiffs that are before courts are people rightly before court, my dear. And it's for the proper administration of justice. Otherwise, we then run the risk of setting a precedent that would say that, look, we think we've got public standing for whatever reason, but we ask the court to pronounce on it once we've led the merits of our case. It cannot work like that, my dear. For me to stand before you, it's called standing. I need to have it up front, not post the fact. And if it is objected to at the outset, then it must be dealt with at the outset. And it's not for the court to pronounce after that, after considering your participation. They've muddied the waters the entire case, for the court to then blow out, you had no right to be here. The court must make that determination at the beginning. And then we are left with the right people. If SAPA fires this team tomorrow and employs another team, that basis to say they've got the same team cannot be a premise to grant them standing. Or if they decide to subdivide and get two different teams, the second plaintiff is entitled to appoint a different legal representative, a legal team. They're entitled to it. So we cannot. This SAPA is not a subsidiary of Outa. It's not.
But that has never been alleged. We all know on what basis the first plaintiff is here, and we know the basis for the second plaintiff.
Not for sure, Marie. The point I'm making is that the basis of them having the same legal representatives cannot be a basis to grant them standing.
No, obviously not. I'm just asking in what way will their presence impact on the trial? And that's what, but you've answered that, so I've heard you.
Thank you, Marie. Now, to go to the point further, I'd started at section 69, specific relief against directors. Then you get section 71 of the Companies Act, and it gives standing to people who can bring action. Same group of people. Nobody may remove a director of a company in the public interest. It's not there. Section 165, derivative actions taken, grants no standing to people acting in the public interest. Why so? Oh, then we get to section 20 of the Companies Act. People who may declare or make a declaration on validity of company actions provides the same grouping of people. Nothing provided for in the public interest. Why? It's conscious on the part of the legislation to say only people with a direct interest in the running of a company may intervene in certain ways. So, even if we grant them standing in the public interest, which is still, in my view, a very remote possibility, they cannot be granted that relief. So, how can they be in the case when there's already uncertainty as to whether they are entitled to the relief they seek? Because there is no possibility that you can be granted standing if the court already knows that you are not entitled to the relief that you seek. It's not there in the legislation, Maridi, because I will tell you what may be granted in the public interest. It's provided for under Section 156, which is the parent which gives rise to Section 157 that they come. The remedies that may be granted in the public interest are accounted for in Section 156. And none of those remedies pertain to direct actions taken against directors. It cannot. It's not there. And this brings us to the proper interpretation of Section 162, is that in as much as 1571D may say things may be granted in the public interest, because Section 157, it says anybody may apply for standing to enforce any provision of this legislation. Now, the issue is, if legislation is capable of two meanings, which is the meaning that you prefer? Well, South African Transport Services versus Olga tells us, the appellate division case of 1986. It's clear. We've got to go with the definition that is more consistent with the purpose of the legislation. And what is the purpose of the legislation? The purpose of the legislation is the following. You cannot act against directors in any way, shape, or form under the Companies Act acting in the public interest. It is not there. Whether it's delinquency, whether it's removal, or any other remedy available against a director, whether it's a state-owned company or it's a private company or a listed company, a public company. It is not there to be exercised in the public interest. And in light of these conflicting provisions that say that you may not act in the public interest or enforce the provisions of the legislation, we rely on the decision of Shoprite Checkers versus Ramdo and others, where it says, where two provisions exist, the essence of that case is that you've got to prefer the specific provisions over the general provisions. And what the issue was in that case was that Section 158 of the Labour Relations Act allows for reviews in general, and Section 145 allowed for the review of arbitration awards. And what was at issue at that point was an arbitration award. And the parties there were relying on 158, saying we can come under 158. And the court says, no, you've got to come with the specific provision. Section 162, read with Section 69, is consistent. It may not be done in the public interest. And we go to the case of Dudu versus Krugersdorp municipality, where the principle states that a court should strive to interpret legislation in such a manner that evasion of its provisions is prevented. So, we should strive in this court to interpret Section 162 the best way Section 162 can be interpreted, correctly. And we cannot read into Section 162 public interest. And we cannot use 157 to override the provisions of Section 162. Now, I've made the point earlier on to say, if indeed public interest existed, and it was intention of the first plaintiff to bring an action in the public interest, what should they have done? One, they could have brought an application to the parties listed under 162. Two, to compel them in the public interest to enforce 162 because they have standing. True. In circumstances where these other people either refuse, then come to court and say, all the people listed under 162.2 refuse or are dragging their feet or are reluctant to enforce these provisions, we seek leave of the courts to enforce them in the public interest. That is the process they should have followed. But now that point is moot in as far as the second plaintiff is here. The second plaintiff is entitled to the relief. Let them stay in the case. The first plaintiff is not, it's time to go home. Because we cannot burden this court unnecessarily with parties to proceedings that do not belong here. It's that simple. So we submit that it's not necessary for this court to add an additional litigant where prima facie it exists that, one, the legislation doesn't provide them the relief. Two, the grounds on which they come are tenuous. Three, people with standing are actually acting. What necessitates you to act in the public interest when a person with standing is acting as per the legislation provides for them to act? What purpose is served by Outa's participation? None. It's a PR exercise for themselves, with respect. Because the Pilots Association has standing in law. One. Two, 162 doesn't provide for public interest. I don't think the courts can be allowed to condone publicity stunts, with respect, my lady. You've got the right people in the second plaintiff, let's proceed with them. Outa doesn't have standing under the section. Nowhere. It's not provided. And the interpretation of Section 157 157 starts at 156. And what 157 says at the beginning, it says, for the enforcement of remedies, extended standing is granted to parties listed under one sub. Enforcement of the remedies listed under 156, extended standing is granted to parties listed under 157. So, the remedies which pertain to section 157 are confined to 156. And in the alternative, that point is not accepted. We say the legislation is consistent in not providing any actions against directors in the public interest. And there are persons, in the instance of SAA, the shareholder, the minister, you can write to the minister, you can bring the minister to court to compel them to act in the public interest. You don't have to compel, in this circumstance, the Pilots Association. But we cannot create law that's not there. And the law that is not there in the circumstance is the law that says you may declare somebody a delinquent director in the public interest. It is just not there, my lady. And on that basis, I say the 157 would have never been granted because the standing didn't exist to begin with. And that is why the leave of the court would have never been granted, because that would have been the second question to be asked, is what is the relief that you seek, and on what basis are you entitled to that relief in law? They would have then had to make out the case to say, under 162, we are found at standing. But they couldn't make that case because it's not there. And I've got no further submissions for it. Thank you.
You haven't dealt with the costs of the joinder and the amendments.
My lady, I would pray that those two be stayed, my lady, on the following ground. The special plea in our submission, my lady, in terms of the hierarchy of issues to be determined as points in limine, we submit that standing is at the forefront of the line. And only once we have guidance on whether parties are properly before court can we then have a determination to say who is entitled to what costs. Because if the court can come to a finding that one party is not entitled to certain costs, those costs cannot be
No, but if you're successful in a special plea, obviously you will be entitled to those costs. But on what basis can you be entitled to the costs in the joint and amendment application?
Well, we just pray, my lady, for that one. In as far as costs are concerned, only those costs as they pertain to one, the amendment themselves, and no cost be made unto the joint application, because the birth of the joint application is the pleadings, my lady. We asked to join the board based on the fact that the board is continuously pleading in the case. And in our assessments of the legal issues, it wasn't frivolous. It was based on the fact that they've continuously pleaded the board. And there's merit in having consideration for the board to be joined. And so I do not think that we should have an adverse finding, of course. So on the merits of the joint application, my lady, we pray that no cost be granted. And with regards to the amendments, well, the amendments weren't granted, so they incur no cost. There's a cost to apply or to object. There's a cost to objecting, and I think
no, but there wasn't a hearing, an application.
I'm saying the only cost is to the objection. Yes.
Time was taken up as a result of the amendment application and the joint application.
Well, rightfully speaking, my lady, like I said, my lady has not made a finding along the lines of saying that the applications were frivolous.
No, but I need not. It's only when I grant a punitive cost order that
yes,
the frivolity of an application is relevant.
I'm starting at that point.
The usual rule is that if someone is successful, they are entitled to the cost of that application at least.
Indeed so, my lady. Where our starting point is to try and pull you away from the thoughts of punitive costs to bring us to reasonable costs, my lady. And we would ask that if such cost orders are granted, they be taxed in the end, my lady, and they not be taxed immediately. Upon completion of the case, there must be costs in the cause, my lady. They cannot be taxed immediately. Thank you, ma'am.
Thank you, Mr. Butalezi. Ms. Steinberg.
Milady, may I hand up a bundle of authorities?
Yes, you may.
Just going to add to just
Yes.
Milady, if we may start with the pleadings. Does Milady have the pleadings bundle here?
Yes. Thank you.
Milady, page 9 of the bundle. That is where, in the particulars of claim, standing is pleaded, together with jurisdiction. At paragraph 15, Outa has standing to bring and does bring this application under 1571C of the Companies Act in the public interest with the leave of this court in terms of 1571D of the Companies Act. Outa's interest and the public's interest arise from Outa's primary objectives. These include the protection and advancement of the Constitution, as well as the promotion of effective, practical, and enforceable taxation policies which are free from corruption, and the proper management of all major public entities. SAPA has standing to bring and does bring this application on behalf of, just to summarize, 171-157-1A of the Companies Act and 1571C. Then paragraph 18, SAA is a major public entity under Schedule 2 of the PFMA. The public has an interest in the proper management of all major public entities, and SAA is a recipient of shareholder guarantee loan of 19.1 billion issued by the state at the date of the summons. That's more than trebled, is what we read in the newspapers. At all material times, SAA was technically insolvent. Paragraph 21, Outa seeks the leave of this court in terms of section 157(1)(d) of the Companies Act to bring this application in the public interest. Ms. Myeni's conduct in the performance of her director's functions within and duties to SAA has breached, first, the Constitution, and in particular, sections 195 and 217, 195 concerning good governance, 217 concerning procurement, and 2, the PFMA and the Companies Act as detailed in these particulars of claim. Now, how is that answered in the plea? If Milady goes to page 101, So first is the special plea. In paragraph 15 of the particulars of claim, plaintiffs plead that Outa has standing to bring and does bring this application under section 1571C of the Companies Act in the public interest with the leave of this court in terms of section 1571D of the Companies Act. First defendant denies that Outa is acting as a member of or in the interest of a group or class of affected persons or an association acting in the interest of its members as contemplated in 1571C. First defendant denies that Outa is acting with the leave of this court and avers that Outa required the leave of this court before instituting these proceedings. Accordingly, first defendant avers that Outa did not have standing to bring these applications. So, my lady, what is pleaded there is a substantive complaint in respect of 1751C in paragraph 2, that Outa is not a member of or in the interest of a group or class of persons, and a procedural complaint in respect of 1571D because Outa did not first seek the leave of the court before filing the particulars of claim. We say, my lady, that is the basis on which this should be heard. We will, of course, respond to the substantive allegations around the public interest. But strictly speaking, our submission is that that is not before the court. Now, my lady, what does Ms. Myeni's plea say about the public interest? Outa pleaded that there is a public interest in the management of major public entities like SAA. That was paragraph 14 of the plea and forward. Particularly at paragraph 15. Sorry. Oh, excuse me. Paragraph 18.1 of the plea. Outa and both plaintiffs pleaded that SAA is a major public entity under Schedule 2 of the PFMA. The public has an interest in the proper management of all public entities. And in the plea, my lady, at paragraph 11, on page 101, that is admitted. So The plaintiff has admitted that the public has an interest in the proper management of all public entities, as she must do. And my learned friend should be confined to those pleadings.
But here they say that leave should be sought. What do you say about that?
Milady, I will address the court on that point. Would the court mind if I took a longer route to answer that
Yes.
point?
You may proceed.
Milady, in the bundle I've just handed up, there's a handout of a few sections of the Companies Act,
Yes.
which I've also given my learned friend. Now, Chapter 7 of the Companies Act is called Remedies and Enforcement, and Milady, in brackets, sections 156 to 184. So it includes 162, just looking at the structure of the Act. So before I look at these sections more closely, if my lady will just note that 156, the first section in this chapter, is alternative procedures for addressing complaints or securing rights. 157 is called extended standing to apply for remedies. Lady, I will take the court properly through these provisions. Just at the moment, the structure. If my lady turns the page, 158 is remedies to promote the purpose of the Act. And then I've skipped a few sections which are not relevant, but Part B of this chapter, called Remedies and Enforcement, includes Section 162. So the simple point I'm making is that 162 is part and parcel of the same chapter in which we find 157. Now, my lady, 156, section 156 is called Alternative Procedures for Addressing Complaints or Securing Rights. A person referred to in section 157 sub 1 may seek to address an alleged contravention of this Act, or to enforce any provision of or right in terms of this Act, a company's memorandum of incorporation or rules, or a transaction or agreement contemplated in this Act, the company's memorandum of incorporation or rules, by, and Milady C is relevant here, applying for appropriate relief to the division of the High Court that has jurisdiction over the matter. So Outa says it is attempting to address an alleged contravention of this Act, not only the PFMA, and to enforce a right under this Act by applying to this court. Then we go to 157, which is called extended standing for remedies. When in terms of this Act, an application can be made to, or a matter can be brought before a court, the company's tribunal, the panel of the commission, the right to make the application or bring the matter may be exercised by one of four categories. And A is, it can be exercised by a person directly contemplated in the particular provision of this Act. In this case, milady, it would be the party, the person directly contemplated in 162. That's the provision we're using. Or the following three persons. A person acting in the public interest with the leave of the court. So, milady, the plain wording of 157, it's called extended standing, and it says there are certain categories of people who are given the right in a specific provision like 162 to bring an application, but we extend that. We extend that to a further three classes of persons, including a person claiming to act in the public interest.
But what about 1573?
I'm about to get there, milady. 1573 makes an exception to that rule. It's an express carve out from that rule. It says that is not the case in 1651, which is derivative actions. So it expressly carves out one section in the whole of the Companies Act. You don't see 162 here or any other section of the Act carved out.
So you say this specifically deals with 165?
Yes. And milady, the court well knows the rule of statutory interpretation, that where there is an express reference to one section, one must assume that the legislature intended not to include the other sections, or otherwise it would have. If it had meant to carve out 162, it would have said so, like it did with 165. It's a common rule of statutory interpretation. So what the public may not bring is a derivative action. Now, Section 158 tells us why these remedies are included. It's to promote the purpose of the Act. When determining a matter brought before it in terms of this Act or making an order contemplated in this Act, A, the court must develop the common law as necessary to improve the realization and enjoyment of rights established by this Act. And my lady, just to pause, this standing, 1571, it says that it is the right to make application. So when we talk about rights, we look at the same word used in 157. 1. The right to make the application or to bring the matter.
Ms. Steinberg, but under the circumstances, if I look at 1571D, acting in the public interest with leave of the court, does that not mean that this leave should have been brought or should have been requested prior to the institution of proceedings?
Well, my lady, there is one case that's been decided on that issue.
Yes.
That is the Redissa case, which is in my lady's...
Is it in this bundle?
It's in the bundle. My lady, we've included the High Court case and the SCA case. And my lady will see that the High Court case was overturned, but not on this point. So it is the only good law we have on this point. And We address this issue in our heads at page 4, my lady. Paragraph 11 defines the dispute, the narrow question of timing and procedure, whether under section 1571D, whether leave under that section is required before instituting proceedings, and B, whether a formal application is required. And we say no, and over the page we explain why. So, milady, paragraph 13, in the Redissa case, which is a judgment of the Western Cape Division, Henny J. held that leave to proceed in terms of section 1571D can be granted at the hearing of the matter without the need for a prior application. In that case, the respondents argued that the Minister of Environmental Affairs could not rely on section 1571D in bringing urgent provisional liquidation proceedings, as the Minister had not yet obtained leave before instituting proceedings. The respondents further relied on case law dealing with class actions in civil claims, which requires a certification process prior to the institution of class action litigation. Henny J. distinguished class action proceedings from public interest standing under section 1571D. He further held that the leave requirement under section 1571D is a flexible, context-sensitive requirement. Quote, in action proceedings, which are usually more delayed than proceedings on motion, as in this case, the exigencies of the matter would dictate whether the court can ascertain on the papers whether relief should be granted without a special application, or whether a separate substantive application should be brought to determine whether the matter should be certified in order to grant an extended standing. Henny J. held that it was sufficient that the Minister made out a case for public interest standing in the papers filed in the main application. A separate prior application for leave was not necessary. The SCA subsequently overturned Henny J.'s judgment on other grounds, but did not take issue with this proposition. Relying on Henny J.'s judgment in Redissa, the authors of Henochsburg summarize the position as follows. If a court can, on the papers, whether in action or motion proceedings, decide whether relief should be granted, a separate application for certification to grant extended standing should not be required. This case is not a class action where a much more controlled method of certification is required. And our submission is that this is indeed a case where the court can determine Outa's public interest standing on the pleadings alone. The lady, Outa could have replicated, but it didn't, because public interest was admitted. My lady, this court divined a notice of motion from an application brought by my learned friend for amendment and frankly for joinder, which was just brought in terms of the wrong rule. And in doing so, this court put substance over form. This court found, I could see what you wanted from your application. Well, if the same principle is applied here, and in this case, unlike in my learned friend's case, with the backing of a court, another court, there's no reason for a freestanding prior application. Outa sought leave in the pleadings. Outa's public interest was admitted. It's not at issue, my lady. And just a few points on questions of form and substance. The court has a discretion in terms of 1571D as to whether to insist on a formal application or not. Now, in exercising this discretion, the court should be guided by the general principle that substance must be placed over form, especially in procedural matters. And my lady, there's a long history of cases that my lady would be well aware of that make this point. If I may refer my lady to the Trans-African Insurance Company case, and that is, my lady, this is not in our heads, if my lady wants to jot down the reference. Hmm? Oh, my lady, I believe you've got an augmented bundle of authorities, and it's on page 47. And then on page 48, my lady, there's a paragraph that starts, each case must of course be decided. My lady can find that paragraph.
That is page 48 of the authorities bundle.
Yes, my lady.
Yes.
Paragraph starting each case.
Can't seem to find it on page 48.
It's on page 278 of the judgment itself, if that helps.
You know what? Let's take the lunch adjournment, and then maybe if you can just point it out here in the authorities bundle.
As the court pleases.
So the court will adjourn till 2 o'clock.
Let's do all the cases.
in time, should the court consider the Companies Act and Outa's entitlement to the relief? My prima facie view is that the court should not go there, because the court might come in the end to another finding regarding whether Outa is entitled to the relief. And if the court decides that now, it might be prejudging the final matter, the final issue between the parties. Or do you think such a concern is not, does not have foundation?
My lady, I'm not sure if I understand the question.
Despite the fact that Outa might have the legal standing to
Yes.
be in court,
Yes.
might not of necessity mean that they are entitled to the relief.
My lady, I think the full answer to that question, my lady's prima facie view, is dealt with in the Constitutional Court case of Giant Concerts, which is, it's in that bundle on page 12. Paragraph 32 of the unanimous judgment of Cameron J. In determining Giant's standing, we must assume that its complaints about the lawfulness of the transaction are correct. This is because in determining a litigant's standing, a court must, as a matter of logic, assume that the challenge the litigant seeks to bring is justified. As Hoekstra explains, the issue of standing is divorced from the substance of the case. It is therefore a question to be decided in limine at the outset, before the merits are considered. So, my lady, it's not Outa's view versus Ms. Myeni's view. It's the Constitutional Court's view that you divorce the question of standing from the substance and the relief. Either you have standing or you don't have standing.
So if we didn't hear the special plea today, we would in any event have started off the trial with determining this issue first.
Yes, my lady. As one often does.
Yes.
With special pleas. They're usually heard
Yeah.
Before the merits.
Even if there was no special plea, the standing must be determined first.
Yes, my lady. And particularly if there's a challenge. But of course, one starts with standing.
Yeah.
So, standing has nothing to do. If my learned friend is correct that 162 precludes at the outset, it allows for no public interest standing litigant, then this court must find now that Outa is not before this court. In other words, if for example, this was a derivative action in terms of 165 of the Companies Act, this court would have to find that Outa simply doesn't have standing, because the Companies Act says that Outa doesn't have standing. There can be no public interest standing. But the moment there can be public interest standing, then what the substance of the case, the Constitutional Court tells us, the substance of the case is not relevant, and nor the relief sought beyond that narrow issue. So the two issues then, and perhaps I started in the wrong order. I started by arguing why, substantively, 162 may be brought, an application in terms of 162 may be brought by a public interest litigant. And then the separate point is the application at paragraph 21, seeking leave of the court, sufficient or isn't it, in the circumstances of this case? No, the one I had marked up. Excuse me, Malay. I had one marked up. It doesn't seem to be. Yeah, it's a pity. Milady, there are two yellow stickies on Milady's bundle of authorities. And I'm just going to make reference to those cases in order to fortify the submissions that I made with regard to the dictum of Schreiner J.A. The first is in the Dengetenge Holdings case, which is a case of the Constitutional Court, paragraphs 135 to 136. And Milady, the court there said, it is apparent from the special circumstances of this case, set out fully in the main judgment, that if Southern Sphere had applied for exemption, in all probability the High Court would have granted it. In these circumstances, to remit the matter to the High Court for an application for an exemption to be made would be tantamount to placing form over substance. Accordingly, I hold that a remittal solely for that purpose, is neither justified nor warranted. Ordering a remittal here would constitute a waste of time and resources. Scarce judicial resources must not be spent on mere formalities, which are not dispositive of a real dispute in particular litigation. Now, Outa are not in this position. There is an application. In Dengetenge, there wasn't an application. There is an application before this court. And that application is now being heard. So, bringing it on notice of motion now would merely be a waste of judicial resources. But, Milady, we have another 4 days this week, and we can do so. We would suggest it's a waste of judicial resources, that there's enough on the pleadings, and in terms of the law, there's enough admitted on the pleadings to find that Outa should be admitted. The other case on your yellow sticky, the Gavrik case, again the Constitutional Court. In my view, the applicant has in substance made out a case which would justify the granting of the exemption. To require a formal application in these exceptional circumstances, where not even the decision maker was aware of the internal remedy, is tantamount to placing form over substance. And, my lady, I remind the court again, that is precisely the approach this court took towards my learned friend. At least we have an application before this court. My learned friend did not. Twice. Milady, the other reason we submit this would be a waste of judicial resources is that Ms. Myeni itself admits that her challenges to Outa's standing is moot. That's at her heads of argument at para 36.
That was the other question that I've asked is, say for example, I would find against Outa. What would be the impact on the trial?
Zero impact, my lady.
Then the second defendant will just proceed. You are representing both parties.
Yes, my lady. Nothing at all will change. Which is the case in which the court made that finding?
It's an LHR. It's an LHR.
Yeah, it was the case in the LHR case to which my learned friend referred. Nobody has. Page 27 of the bundle, paragraph 23. The court held there that the involvement of the second applicant in the proceedings would have resulted only in a minimal increase in the costs of the proceedings. There is therefore no need to determine whether she had standing.
You see, that was my point. Even if I find against Outa, then...
Well, my lady, you're supported by the Constitutional Court. My lady would know better than me that courts are asked not to determine what is moot. And that is part of why in my introduction I suggested to my lady that she confine her findings to the question of whether there's technically an application before this court. And, well, if there isn't, there isn't, and it's moot either way, actually. It's moot. And whether or not the second plaintiff briefs new counsel or does, it doesn't matter, my lady. Those are the pleadings.
Well, that's in the realm of speculation.
Indeed, my lady.
I cannot see that happening on such short notice.
No, my lady. So my lady's prima facie view is supported by the Constitutional Court. It's moot. And my learned friend was well advised to initially withdraw the special plea because there's no point to any of this, my lady. And my learned friend protests that they have a right to know who stands where at the beginning. But in the face of, if it were just Outa bringing this action, yes, he would. But since it's going to make no difference to Ms. Myeni, there's no reason, there's no authority that he's given you to support such a view. The contrary is the authority. But, my lady, since we are arguing about the substance of whether or not Outa comes in the public interest and whether it's entitled to come in the public interest in a 162 application, with the court's leave, I'd like to continue with those submissions. Yes. So, my lady, I was referring to the little handout I gave my lady with the Companies Act sections. So, my lady, we were up to section 158. And so we'd established that 157 extends standing to those who have a right beyond those named in the particular section. 158 says, when determining a matter brought before it in terms of this Act or making an order contemplated in this Act, a court must develop the common law as necessary to improve the realization and enjoyment of rights established by this Act. And I pointed out to my lady that standing was phrased as a right in section 157.1. The Commission, the panel, the company's tribunal, or a court must promote the spirit, purpose, and objects of this Act and if any provision of this Act or other document in terms of this Act read in its context can be reasonably construed to have more than one meaning, must prefer the meaning that best promotes the spirit and purpose of this Act and will best improve the realization and enjoyment of rights. So this is the legislature saying, be generous, extend rights to those categories we've indicated, and it is worth looking then at the purposes of the Act. And on the last page of this little handout, milady, we have reproduced the purposes of the Act, and I would draw milady's attention to A, the purposes of this Act are to promote compliance with the Bill of Rights as provided for in the Constitution in the application of company law. And milady will note that particularly with respect to the BNP part of this application, the right that the plaintiffs seek to defend is the right to just administrative action in making procurement decisions, among others in the Bill of Rights. B, promote the development of the South African economy by, and if I could go to little Roman numeral 3, encouraging transparency and high standards of corporate governance as appropriate, given the significant role of enterprises within the social and economic life of the nation. Now, Outa's raison d'etre is the encouraging of transparency, high standards. How is taxpayers' money spent? It's the organization undoing tax abuse. It lives for that. That is one of the purposes of this Act. And if milady will go to J, encourages the efficient and responsible management of companies. Well, on each of the 4 transactions, the allegations are inefficient and irresponsible management. So 158 says this court must contemplate the purpose and objects of this Act and must make a finding in terms of standing and ultimately the orders that best promotes this Act.
Well, in the purpose of the Act, the Companies Act is now directly linked to the Bill of Rights and the Constitution.
Correct, milady. So it's one of the profound amendments in the new Companies Act, is to bring the Companies Act in line with the Constitution. And it does so in many respects, including standing, remedy, and the objects. There was a time when corporate law was somehow isolated from public law, but the Act has remedied that. And milady, that's even with private companies. This is with a major state-owned entity, which is governed by the PFMA as well as the Companies Act. So, milady, then we get to section 162. And it is part of the chapter on extended remedies. And it says at 162.2, a company, a shareholder, director, company secretary, or prescribed officer of a company, a registered trade union that represents employees of the company or another representative of the employees of a company may apply to a court for an order declaring a person delinquent. Now, milady, if you'll just page back to 157. (157)(1)(a) says, when in terms of this Act, an application can be made to or a matter brought before a court, the right to make the application or to bring the matter may be exercised by a person A, directly contemplated in the particular provision. Now, those are the people, the categories of people directly contemplated. That's 162.2. Or another 3 categories of people. So the plain wording is clear there, my lady. In the Radisa case, and again, this bit was not overturned. The Cape High Court, Henny J, found what he was faced with was an applicant wanting to bring an application in terms of 157.1, in other words, someone who wanted to act in the public interest. In respect of a provision outside of this chapter, and he found in that case that even if the provision is outside of this chapter, because of all the indicators to which I've pointed, my lady, even then, it's permissible to grant public interest standing. And that was to Section 85, I think. Section 85, liquidation application. Here, we're dealing with the very chapter in which the remedy is extended. And what's interesting in the Radisa case is what was overturned on appeal was this. The court said that the minister who was given public interest standing to bring the liquidation application shouldn't have brought the liquidation application because it is such a severe remedy in the context of a company that's solvent. The SCA said what she should have done is brought, under her public interest standing, a Section 162 application. Can you just find me the exact reference? So that's the SCA. And that case is there, my lady. We'll find it for you in a sec. It's on page 45 of my lady's bundle, paragraph 138.
So do I understand this correctly? Here the SCA says that the minister, who is not a director shareholder, obviously, should have brought an application in terms of Rule 157. Oh, well,
162.
162.
Yes. So the quibble was not with the 157.
Yes.
The quibble was with so it wasn't with her standing. The quibble was with the section of the Act that she wanted to use against the company. And they said that is a very drastic, that So the court did not say it can never be in the public interest to bring a Section 85 liquidation application. It said in the circumstances of this case, where the company was still solvent, it was too radical a section to use. She should have rather used 162. In other words, she should have, instead of trying to put a whole company into liquidation, she should have targeted some directors.
So, do I understand this correctly? So the SCA gave a wider interpretation to 1622 than the wording that's contained there?
Not directly, my lady.
Not directly, but by
Yes, my lady.
implication.
Yes, my lady. The implication was that the problem was not her public interest standing,
Yes,
that the court was not overturned on that basis.
yes.
The problem was that she didn't use 162. She used a more severe penalty. And again, not because she didn't have standing to, but it was inappropriate.
Yes.
My lady, there's another reason. Sorry, I'll let you finish writing. There's another reason why Section 162 is designed for broader standing, or why wider standing is designed for this section.
Just a moment, Ms. Stein.
Yes.
Sorry, Ms. Steinberg, it's just the outside noise that I tried to
Oh,
contain.
I see.
Yes.
My lady, I might have answered your question inaccurately. The SCA found that the reason she lacked public interest standing was because she brought a Section 85, and that she should have brought a Section 162.
162.
Yeah. So, my learned friend argued, why can there be a public interest in declaring a director delinquent who's long ago left the company? Now, that is answered by the SCA in the Giwala case, which I've just handed up to my lady.
Yes.
At paragraph 142, the SCA said, in order to assess these arguments, it's appropriate first to examine the purpose of Section 162.5. 162.5, my lady, is where the court may make an order declaring delinquency. And the SCA held it is not, this is contrary to the submissions on behalf of Mr. Jiwala and Mr. Manala, it is not a penal provision. Its purpose is to protect the investing public, whether sophisticated or unsophisticated, against the type of conduct that leads to an order of delinquency, and to protect those who deal with companies against the misconduct of delinquent directors. So the purpose of this application is for the court to say to the world, this person is not fit to be a director of a company in future for a minimum of 7 years, or perhaps longer, depending on what the court finds. It's to protect the public. It's to protect other companies. So when it comes to a state-owned entity, again, there's a particular public interest in ensuring that such a person doesn't sit on another or the same board of a state-owned entity if she is in fact delinquent. Otherwise, Ms. Myeni can be appointed to Eskom's board tomorrow, in the absence of a court order precluding her to do so. And that is why Section 162 lends itself to wider standing. Because taxpayers have a direct interest in the directors that manage their funds. Nothing abstract about that. My learned friend referred to a US case. Well, the US's constitution doesn't have special standing, and nor does its Companies Act specifically extend the standing to include the public interest. It's unheard of in the US. The lady, just to carry on with this case, paragraph 143, but just below the line, the sentence just before the little quote, it says, that section makes a director liable for loss or damage sustained by the company in consequence of the director having ABC. Now, the point there, my lady, is that the company itself has a range of other measures it can take against a director who's acted in the manner that Outa and beyond what a company may recoup. It's for everybody else who isn't covered by the rest of the Act. And that, one can see that in the judgment over the page. At the top of the second page, it was urged upon us that there might be circumstances of extenuation, or perhaps that notwithstanding the seriousness of the conduct, the company might not have suffered any loss. But neither of those is relevant to the protective purpose of the section. Its aim is to ensure that those who invest in companies, big or small, are protected against directors who engage in serious misconduct of the type described in these sections. That is conduct that breaches the bond of trust that shareholders have in the people they appoint to the board of directors. And may I pause to say that the shareholder here is the government. And the government here is the public purse. So the minister is the shareholder on behalf of the public. It continues, directors who show themselves unworthy of that trust are declared delinquent and excluded from the office of director. It protects those who deal with companies by seeking to ensure that the management of those companies is in fit hands. And it is required in the public interest that those who enjoy the benefits of incorporation and limited liability should not abuse their position, or more so in a major public entity. The exclusion is for a minimum period of 7 years, but the court has power to relax. And then finally at paragraph 154, the third sentence starts section 162. Section 162 passes that test, that's the test of constitutionality. Patently, it is an appropriate and proportionate response by the legislature to the problem of delinquent directors and the harm they cause to the public who place their trust in them. One final point about the Companies Act. My learned friend referred to section 69, where he said that those were the remedies you bring against directors who are behaving badly. Section 69(5) actually makes a specific reference to section 162. It says that one of the people who may not be made directors of companies in terms of this section are those who've been placed under probation by 162. So the Act does not create segments in any artificial sense. Where it carves something out, it's very clear, as it does in 1573. Otherwise, it actually cross-refers right from the purposes onwards. So, just to read you the wording of the section that my learned friend was dealing with. It says, a person is disqualified to be a director of a company if A court has prohibited that person to be a director or declared him or her to be delinquent in terms of section 162. So there can be no argument that there are other sections that may be used. And if one section may be used for one purpose, another section is then excluded from being used for that purpose. It's there to protect the public. It's under the extended standing and extended remedies. That's what it exists for. And the SCA has told us that the purpose of 162 is to protect the public. My learned friend's argument that somehow the Bill of Rights isn't implicated is wrong in two respects, with respect. The one is that the Act tells us that the mismanagement of companies in this particular manner falls squarely within that ambit. And as I submitted earlier, specifically, we're dealing with the right to just administrative action, which, if our allegations are correct, were broken at every turn. Secondly, it's the wrong test. That in terms of 147, the test is not when in terms of the Bill of Rights, it's when in terms of this Act an application can be made. And this is something that Justice Jafta comments on in an academic article which was quoted in the Radisa judgment. Paragraph 172 of the judgment.
Is that on page 52?
It's page 32 of the new bundle. The article's at 52. So if my lady looks at paragraph 175, paragraph 175. At common law, legal standing is ordinarily linked to the party's own interest. It must be the identified interest of the party instituting the proceedings which forms the subject matter of the case. Legal standing, therefore, is limited to this narrow class of litigants. Barring a few exceptions, no party is entitled to institute proceedings on behalf of another party where none of its own interests are affected. But where a claim is grounded in statute, legal standing is determined with reference to the relevant statute and its purpose. The issue is decided in the light of both the facts and the statute conferring the right or the interest which the applicant seeks to protect. For instance, if a statute contains a prohibition that was enacted in the interests of a particular group or class of persons, any member of that group would be entitled to institute proceedings to enforce the prohibition without proof of damages suffered personally by him or her. Now, my lady, to pause there, the SCA has said in the Jiwala case that the particular group or class of persons is the public. That's who has an interest in delinquency applications. It's a protective provision for the public. But he goes on. Therefore, in passing the Companies Act, Parliament must have been aware of the narrow approach to standing at common law, and the fact in the case of a statutory claim, legal standing is determined with reference to the relevant statute. It cannot be gainsaid that the aim of the legislature encapsulated in Section 157 was to alter the common law position on legal standing and expand the class of persons who may institute legal proceedings. The section has revolutionized legal standing in matters where the Act applies. And then, my lady, he compares the provisions of 171A to D to Section 38 of the Constitution. And I have made a copy to the extent that the court may need it. Because he makes the point that it's almost the same but not the same. He says, whilst the provisions of 157H-D is similar to the provisions of Section 38 of the Constitution, and whilst both provisions seek to broaden the standing of persons as mentioned in the respective provisions, the purpose of Section 38 of the Constitution, in my view, is totally different to that of Section 1571 of the Companies Act. The purpose of Section 38 is to broaden the standing of persons who may approach a competent court in which they may seek relief where a right in the Bill of Rights has been infringed or threatened. Whereas Section 1571 seeks to broaden the standing of persons who would ordinarily not have such standing to bring a matter to court in terms of the Companies Act. Put differently, the extended standing in Section 1571 clearly has not as its purpose to extend or broaden standing of persons to approach a court in which it may seek relief where a right in the Bill of Rights has been infringed. Para 177, it seeks to give standing to persons not ordinarily clothed with such standing to bring a matter before a court or make application to a court in terms of provisions of the Companies Act. Section 38, therefore, deals with standing in a constitutional context, whereas Section 1571 deals with standing in terms of the provisions of the Companies Act. In other words, an applicant for public interest standing in terms of 157(1)(d) doesn't even have to allege that a right in the Bill of Rights has been infringed. That's to confuse Section 157 with Section 38. An applicant in terms of 157(d) must say I'm bringing this application in terms of my rights, in terms of the Companies Act, to promote the purposes of the Companies Act. And that is what Outa does. And that is why I drew my lady's attention to the purposes of the Act. The Heath judgment in the bundle. Should I just leave that, do you think? And, my lady, may I say that our courts have again and again and again recognized the consequences of a decade of mismanagement of major public entities. If Outa is correct, in only a handful of its allegations, then Ms. Myeni is guilty of many years of mismanagement of a major public entity. And our courts have again and again and again said that this is the business of the public and it's the business of the courts. And just a couple of references. There's the Passenger Rail Agency of South Africa case, and that's these are not in the bundle, my lady. Passenger Rail Agency of South Africa, 2017, Volume 6, SA 233, brackets GJ. President of the Republic versus Office of the Public Protector, 2018, Volume 2, SA 100, GP. I think that's probably enough. Just one constitutional court case, my lady. South African Association of Personal Injury Lawyers versus Heath, 2001, Volume 1, SA 883, Constitutional Court. And that's at paragraph 4. The court says, corruption and maladministration are inconsistent with the rule of law and are fundamental values of our Constitution. They undermine the constitutional commitment to human dignity, the achievement of equality, and the advancement of human rights and freedoms. They are the antithesis of the open, accountable, democratic government required by the Constitution. If allowed to go unchecked and unpunished, they will pose a serious threat to our democratic state. And, my lady, I remind the court that in the pleadings, Ms. Myeni accepts, number one, that the whole business of the management of state-owned entities is a matter of public interest. And when it comes to Outa pleading its primary objections, there's no denial. There's a claim that this is abstract. And I'd like to just take a few minutes to respond to what my learned friend says is abstract. He quotes the Lawyers for Human Rights case, which is at page 21 of my lady's pack. So, my lady, in that case, let me take a step back. Outa argues that an abstract challenge refers to a challenge to, in this case, in the LHR case, it was a challenge to the constitutional validity of legislation, but there was no litigant before the court who was affected by it because the department had settled. That was abstract in that it was moot. The hearing wouldn't have had, the outcome wouldn't have affected any person. Here, there's nothing moot or abstract about Outa wanting to bring a delinquency application against someone who might still be a director of companies in the future. So if my lady would look at page 25, paragraph 18 of that judgment. The issue is always whether a person or an organization acts genuinely in the public interest. A distinction must, however, be made between the subjective position of the person or organization claiming to act in the public interest on the one hand, and whether it is, objectively speaking, in the public interest for the particular proceedings to be brought. So the question before the court is it's not subjectively whether Outa claims one thing and my learned friend claims another. The test is, objectively speaking, is it in the public interest for the particular proceedings to be brought? Lady, there can be no argument that it's not in the interest of the public to protect itself against a director who, if they are correct, is delinquent. And according to this paragraph 18, the argument between Mr. Buthelezi and myself as to what Outa thinks it is or isn't is irrelevant. The court makes an objective determination. So in that case, at paragraph 22 on page 26 to 7, the court found that even though it was an abstract challenge, it would still hear it, because if section 34(8) of the Act is unconstitutional, hundreds of vulnerable people could be detained unconstitutionally for short times before their removal. This is not in the public interest. It is therefore, objectively speaking, in the public interest for these proceedings to be brought. So in other words, what the Department of Home Affairs had done is, because the challenge had been brought in respect of a particular individual, they had quickly acted in terms of that individual in order to avoid the litigation. So the court said, yes, it is abstract at some level because that litigant can no longer be affected by the order. However, objectively speaking, it's in the public interest to bring these proceedings because there are hundreds or thousands of other people who may be affected. We're in a much stronger position. Outa says there's nothing abstract about ordering that Ms. Myeni be declared delinquent. It's a real order against a real live person who otherwise wouldn't have that order made against her. The point is, the test that is applied in this case is not what is the character of Outa and what does he say about Outa, we say about Outa. Is it in the public interest for Outa to bring this application? And on page 24, paragraph 14, just for the court to note that Section 38, it says, Section 38 of our Constitution introduces a radical departure from the common law in relation to standing. Indeed, the terms of the section limit considerably the degree to which an analysis of the standing jurisprudence in other countries can be of real assistance. So whether a taxpayer in the US has standing or not is irrelevant to our courts. Lady, I feel like I'm going on and on and on, but what I haven't done, and it is in the heads of argument, and perhaps I must just point the court there. The test in Ferreira v. Levine. Why can't I find it? Page 7. Page 7 of the heads. The test in Ferreira and Levine is laid out at paragraph 18. It's the same test that my learned friend referred to. And at paragraph 19, Outa argues why it satisfies the requirements of this test. And there's nothing here that I haven't covered. So it's merely here, I merely point to my lady's attention that these submissions that I've been making go to why Outa meets the test set out in terms of Ferreira and Levine. And I won't repeat them. Is there anything besides costs?
You didn't say anything about costs either.
Yes, costs. Where are my notes? I don't know why I'm losing myself today. Milady, with regard to the first two applications, there are significant costs merely in the delay. Milady will remember that this trial should have run on the 7th of October, but we were here every day that week. Day one, we had a message that the judge should phone Ms. Myeni. Day two was an arrival of someone not quite on the record to request a postponement. Day three, sort of an application. We were here the whole week. Now, those costs were entirely occasioned by not only those applications, but by the litigants' conduct in bringing those applications. The litigant thought that it was fine to send a message with her opponent's attorney to tell the judge to phone her. And, milady, that is one of the reasons we argue for punitive costs, is for the court to show its displeasure at a contemptuous and arrogant attitude towards this court.
But should the court, under this circumstance, might it not just be a layperson's incomprehension of what is appropriate for a judge to do?
It might be, milady. I have no facts to adduce as to her Yes.
I will take a more lenient approach towards that. People sometimes don't know how the procedure works and what would be appropriate and not. So I'm going to ignore that request in totality.
Lady, I can't take my argument further on that. In the amendment application, there is also months of unaccounted for delay. And
there was a certain delay there, but in that regard, and I'm not saying that the plaintiffs may not be entitled to cost, but right from the start, I also take into consideration that the defendant's legal team was under great pressure. This is a case that's long in the coming, and it would have been very difficult for them to prepare properly within a week or so. So I'm not saying you might not be entitled to cost, but I also take, in all fairness, cognizance of the view that Mr. Buthelezi came in very late, and you yourself will know how complicated this case is, and to what extent he needed to pay within a very short period of time.
Well, Milady, I'm here arguing for punitive costs. It goes without saying that costs follow the order. The respondents were successful and they're entitled to their costs.
Yes.
I'm arguing additional costs. And I say that there was unnecessary delay, firstly in that first week. But secondly, I have great sympathy for Mr. Buthelezi. But the blame for what happened must entirely be laid at Ms. Myeni's door. The plaintiffs in this case played no part in the fact that Mr. Buthelezi was placed under enormous pressure. And that was what the facts in the amendment...
Regarding the cost and the scale, this court has a discretion.
Indeed.
Taking into consideration all the facts that
Indeed, my
might be
lady.
relevant.
My lady. And my submission is the fact that the delays and the pressure that her legal team were put under, the blame must entirely be laid at her door, is a factor that my lady should take into account. The other special circumstance in the amendment application, my lady, is that my learned friend made very serious allegations against two attorneys, and I expressly invited him to withdraw them, and he didn't. And my lady, the court may also award punitive costs to express its displeasure at that behaviour. And as we stand here today, my lady, my learned friend has not withdrawn scurrilous allegations of collusion between attorneys, notwithstanding the fact that there was no factual basis for that on the papers. So, in short, my lady, when it comes to both applications, we say the costs of the delay, in addition to the costs of the application, the costs of the delay are part of the costs of the application. When it comes to the amendment application, we ask for a punitive costs order. In terms of the conduct of the litigant and, in this narrow sense, her legal representatives. Those are our submissions. My learned junior points out that we're looking at costs in 4 matters. The one is the postponement application. The second is the amendment application. The third is the joinder application. And the fourth is the special plea.
Might it not be advisable in a matter like this, seeing that I will hear the trial? Might it not be advisable to decide the costs at the end? This court will be very cautious to pronounce at this stage on the behavior of anyone. If it was another judge, it might have been more difficult. Do you have any views on that? I know you've said that it must be immediately taxable, but we also know that the defendant has stated that she's unemployed. So such an order at this point in time might not really be effective.
Well, my lady, there are measures that the plaintiffs can take to try and make it effective. So I think that's a separate matter. My lady, the wasted costs in the postponements and the waitings, the outcome of the trial will never affect that. Even if the plaintiffs lose everything in the trial, it doesn't justify the costs that were attendant upon a late postponement application, for example. So perhaps one can think of the costs in terms of those that might take on a different complexion in the long run and those that just simply don't.
I'm thinking about the amendment application specifically. The postponement, but the amendment application evidence will be led and it might throw a different light on that application. Will there be any prejudice for anyone if the court should decide to follow that approach?
Well, my lady, there's prejudice to plaintiffs who need to recoup their costs, particularly wasted costs. We're not dealing with deep pockets here. And the plaintiffs would like to tax their costs as they go along, to keep going. So if that is their entitlement, they would like to exercise it. Particularly in the face of a litigant who says that I can't pay for this. It's all very well to get counsel who might not be asking for money. But how are the plaintiffs going to ever be satisfied? The right, again, as with the amendment application, the rights cut both ways. Both parties are affected by these procedural decisions. And the court will note that these are non-profit organizations. As the court pleases.
Thank you. Mr. Buthelezi.
Thank you, Madam. Malady, if I start, I'm going to start with this chapter 7, remedies and enforcement. and state that we don't disagree with the interpretation that is being applied here on the following grounds. Chapter 7 is separated into Part A and Part B. And Part A speaks to general principles as they apply to sections 156 to 159. And if you go to Part B, it speaks to rights to seek specific remedies, section 160 to 165, which is inclusive of section 165, which speaks to derivative actions. Our case was and still is the following. In as far as the public interest is allowed in the Companies Act, it does not extend to actions against directors, it does not extend to actions against the company. I've submitted that circumstances may arise where a delinquency application may be brought in the public interest, and that specific circumstance is where the parties listed under section 1622 fail to act. Now, the reliance on Reddit as an authority, we don't agree with the interpretation that is being applied, because the minister brought an action to liquidate a company using section 157, and the court said you didn't need to liquidate 157. You could have just removed the directors. Now, the minister has standing under 162 as a shareholder because it was a public entity. And that's where the court then diverts the minister to say, you need not liquidate the company in the public interest, but you needed to exercise your powers as a shareholder and remove the directors because the company was solvent. And that is the point we make with regards to our interpretation of 162. My lady, you will appreciate that we interpret authorities differently as counsel. Reading the very same sentence that says the dog crossed the road, we can come to 10 different interpretations of that simple sentence. So we don't agree with Outa's interpretation thereof. What we also don't agree with, my lady, is how Outa then uses the giant Giant Concerts case, my lady, thank you. And they read the Giant Concerts case at paragraph 32. And in reference to their bundle, if you carry on from paragraph 32, you get to paragraph 34. And in that very same case, just one paragraph later, what the Supreme Court of Appeal says about standing is the following. It says, what the Concord cites is saying there, it says, as the Supreme Court of Appeal pointed out, standing determines solely whether this particular litigant is entitled to mount the challenge. A successful challenge to a public decision can be brought only if the right remedy is sought by the right person in the right proceedings. And that, my lady, I think is the crux of it. The right remedy sought by the right person in the right proceedings. We say the right person is the Pilots Association. They've got a right to come to court. It is the right proceedings. We do not see what Outa says in their papers establishes a public interest. What we are against is the following. Is coming to court and throwing around buzzwords. South African Airways, corruption, and maladministration, the Constitution. If you read their papers, my lady, if you read their papers, nothing of the public interest arises. And what actually does arise is what was said in the previous submission, is the following, which is what we'll get to in the trial. She says, in particular, procurement decisions regarding BNP. This case, my lady, is not about the public interest, it's about commercial interest. And I will tell you 3 things about this case, my lady. The first one being, the BNP capital, it's pleaded. It's about frustration that one transaction advisor was preferred over another by the SAA board. Number 2, in the Airbus deal, we will get to it, my lady. It's about the fact that somebody was saying, buy 10 aeroplanes, we can make the commission of 10 aeroplanes, while the first defendant was saying, buy only 2, we can afford 2. It's about saying, let's finance these planes locally, while somebody else was saying, let's finance it overseas. Where is the public interest there? It's about saying, in the Emirates deal, somebody was saying, let's give the South African international routes to an international airline. The first defendant was saying, look, we don't have proper information, let's scrutinize this. Where is the public interest? Because these are commercial interests. And if you look at the scale of what 13 reports, they only speak of the Ernst & Young reports. We're going to discover 12 other reports, the ENS reports, that speaks to wide scale.
Well, that's not part of the papers before.
No, we're going there, Marie. The point I'm going to, Marie, is that it's very convenient to come to court and claim public interest. And what I'm pointing my lady to is to say, when we read these papers, what emerges? What does emerge from these papers? These papers are about 3 commercial transactions. 3 specific commercial transactions that were expected to go in a certain way and didn't go in a certain way, and somebody's retaliating. But we'll get to that. The point I'm making to her is this simple point. There is nothing pleaded that raises a public interest issue. And the court can't be misled and have the wool put around the court's eyes to say, the moment we say SAA, de facto then it is a public interest issue. I think the hurdle is a lot higher. They need to have said more. If you go where they then claim public interest in the particulars of claim, I think it's at paragraph 16 or paragraph 21, one of the two, I don't know if those papers with me. Huh? It's a paragraph 18, sorry. It's very early in their particulars. They say, we want to protect the Constitution, and because we are Outa, we have standing. And we act in the public interest. Now, it goes back to the earlier point where we were talking about the leave of the court. Leave of the court is not here for the taking, at request, or upon request or demand by the parties, to say, well, we haven't brought an application. We are not saying Outa must bring an application to grant them standing. No, in section 157. We are saying the following. In as far as we are here now, you have not complied. Substantively. Not procedurally, even substantively. Procedurally, yes, you should have brought an application on notice. Substantively, you should have persuaded the court to grant you standing based on these 2 principles. 1, you are acting in the public interest. 2, you are entitled to the relief that you seek. Now, we go back to the point where I started. We say, look, this interpretation that is now preferred around how we read 157. 157 it's on these very notes. It says the general principles, alternative procedures for addressing complaints and securing rights, and then extended standing under 157 to apply for remedies. Section 1, Part B, it says rights to seek specific remedies. 162 is a specific remedy. That's the category within which it falls under, and is specific to the parties who are parties to it. If you read the commentary under section 69 in the Hennocksburg commentary, it says it. Like section 69.5 says people may be removed under section 162. if you read the commentary section of 169.5, you find the following. There's a subheading that says applicants, and it goes into details of who may be applicants in accordance with 69.5, and it's very specific. And the point we were making earlier on is to say there are remedies in the Act available to the public. We don't dispute that. But there are remedies that are not available to the public. Now, to the extent that they say only 165 is not applicable to the public, well, where does 165 fall under? It falls under this very same section B of specific remedies. And to say, well, 165 is the only one excluded, that's not correct. I say, we submit the following, my lady. They may, under 162, bring an application for delinquency in the public order, subject to proving that the circumstances warrant that they may be bringing it in the public interest. One, you'd have to fulfill the requirement that the people listed under 162 either have failed or refused to act. That's the first submission we make. Number two, they cannot, because it says they can only act in the public interest for people who cannot act on their own or for themselves. The Pilots Association is acting for itself. What necessitates then the same relief to be pursued in the public interest and then to be pursued in the interest of the trade union in the same action? It doesn't make sense. The Pilots Association has got statutory standing. There cannot be a debate with them. The debate is around Outa, is to say, if the second plaintiff has standing, what's the first plaintiff in court doing? Because this can be achieved, and we'll have less legal debates. There wouldn't be a special plea. There wouldn't be none of this toing and froing and tugging and pulling between us. Now, what we say, my lady, is that if you read the papers properly, we say it's insufficient to use emotive language and buzzwords and proper administration of companies and without actually making out a case for it. And we say there is no public interest case here. The court is being misled. This issue is about transactions. 3 transactions in particular that are being brought before the court. Whether these transactions are used to prove delinquency, the selection of these transactions is most peculiar. Amongst the thousands of transactions that this board was party to, only 3 are selected. We've argued, my lady, repeatedly that this is not what it's supposed to represent. Anyway. So, if they were acting in the public interest, they could have done under 157 and said, we compel the shareholder who has the standing to act. We compel the trade union or the company itself to act, since they have the standing to remove these directors. They did not need to invite themselves in where the law doesn't allow them to invite themselves in. And we make the point again, is that the specific provisions override the general provisions. We've got a different set of understandings here, but we're going with the understanding in the ShopRite Ramdau case where it says where legislation can be interpreted through 2 different provisions. The one that is more specific, my lady, enjoys preference. And in extension to that point, my lady, what they don't state is the following. They don't answer my point at no point that says actions against the company and actions against directors may not be effected in the public interest. under Section 71, Section 20, Section 69, and actually 162. It's consistent. The Act is consistent where actions may be taken against directors. It provides wide powers, but not to the public interest, because these are a specific grouping of people. It's a consistent grouping, my lady. And what this grouping has in common are people with a direct interest. The trade union has a direct interest. The shareholder has a direct interest. Other directors have a direct interest. It's no mistake, it's no omission that all the sections that speak to direct actions against directors or direct actions against the company exclude the public interest. And this reading of 157 outside and wanting it to then blur out the section that says rights to seek specific remedies under Part B is a distortion, my lady, with respect. It misrepresents what those sections are intended to be. And in as far as saying the purpose of the Act, as per Section 7, we agree. That's why we don't deny it, that the national carrier, somewhat, issues of the national carrier do raise public interest issues. We don't deny it. But then, if that was our position, then how did we arrive at the position of the special plea? We say issues of the national carrier, in principle, will raise issues of public interest. But it's not a free-for-all for whoever can come to this court and make allegations about SAA to be automatically be granted standing. You've got to do more than that. We cannot be at paragraph 16 and 17 and 18 and saying, we're an interest group, we don't like what's going on in SAA, we're going to court. The test has got to be a lot harder than that. Otherwise, then the courts tomorrow, even a WhatsApp group will come to court tomorrow and give itself standing and say, we 10, 15 friends, we're an interest group, we don't like what's happening in this court, impeach the judge. We can open that door if the principles, or we set the bar so shallow for people to confound public interest standing on themselves by the mere allegation that we act in the public interest. And that's why we say the allegation of that, it's in the abstract, remains. Because they say, yeah, for the values of the Constitution, yeah, and for good governance. I think, my lady, it's still very far in the abstract. We needed to come something much more closer to classes of persons affected, to rights of persons affected. It can't just be that our general sentiment is against what is taking place in state-owned enterprises. In the legal context, the requirements should be a lot more stringent. In the public domain and in the media or wherever the people engage, of course, the public interest will set a different hurdle. But for us to engage with the issue at the legal level, we've got to be more than just shouters of angry statements and popular rhetoric, which is the current of the day. The courts, unfortunately, can't just allow people in the door by virtue of the saying we're angry, we don't like what's happening. You've got to say more.
I don't think that's the case.
I beg your pardon, madam.
I think the courts will have to apply the rule of law and the Constitution and the legislation and obviously all applicable authority. Whatever might motivate litigants, that is the duty of the court.
I'm with you, my lady, and I agree with you, because the reason why I raised that issue is because we've already got this situation where leave of the court was not sought. Because if leave of the court was sought, the parties were going to be compelled to make a case out to the courts. And they've avoided doing that. Because therein lay the inherent risk of not succeeding, because you first needed to persuade the courts on the strength of your own argument, which we say is still absent. And it's how they've come at it now is a tactical maneuver to bypass that process. Because where we are now is they say there is an application before the court. It's one line, my lady, wherefore leave of the court is requested. One line.
You said that you're not suggesting that they should bring a formal application, because we can do that.
No, I'm not saying that.
We can do that. We've got 4 days left.
No.
So we can accommodate that easily.
No. I'm not saying they must bring it, my lady. It's not going to change anything substantively. What we are saying, based on what they've pleaded, even if we were to grant them the benefit and say, let the court grant the indulgence over the substance of the issues.
Well, the court did that for the defendant.
Yes, and my lady, I'm grateful. And neither do I hold them to the form thereof. I say, leave the form one side. Let's talk to the substance thereof. The substance is still hollow. The substance is hollow. And the reason why I speak of the form thereafter is to say, had you come alleging these grounds in a formal application, you would have not have succeeded. And that's why they didn't do it. Because they say, based on what we've pleaded here, we request that the court grant us standing. And if you read those paragraphs between 16, 17, 18, where they say why they should be granted standing, it's not sufficient. And that's what we then protest to say, based on what you've pleaded, you haven't made out a case to be acting in the public interest. Based on what you've pleaded in your papers. Because had you been granted standing through 157D, 1D, that issue would be settled. But for the fact that you now come after the fact to seek it, fine, we'll allow you in, we'll infer it from your papers, as the authorities say. But if you look into what is in their papers, nothing in there speaks about public interest. There's an issue in the last pillar of the case about the EY report that says the board did not take actions or the recommendations of the EY report. Perhaps, maybe, there I could make a few concessions. But on the other 3 issues, nothing in there raises a governance issue. It's all transactions. It's all about disputes about where this transaction went versus where it should have gone. This is what we thought we should have been. It's a dispute between directors over who voted how and who didn't vote how. That's all it is. Which is par for the cause. We'll lead evidence on that when the case resumes. But if you read the pleadings as they stand, the particulars of claim, no public issue is raised. Public interest issue is raised. And we say, my lady, it's not sufficient to just come to court and then say SAA, and now that the airline is in financial problem, it's by default a public interest issue. No, the merits of your case need to speak to public interest as well. And like we say, my lady, you can't just allege, and on the basis of these are the new buzzwords, these are the new issues in the country, whatever you bring to court.
I'm confined to the papers.
Yes, my lady.
And I'm confined to the pleadings. But I think we can all take, but I think it's irrelevant for purposes of this action before me, the state of the airline presently. I am limited to the case before me, and that is the case that this court will determine.
Well, my lady, I'm not too sure, because you posed a question to me earlier, which asked me...
Well, if I exceed the boundaries of what is before me, you will definitely have the right and privilege to take this court on appeal, but you can't assume at this stage what this court will and will not find in the merits that will only be determined during the trial.
The point, my lady, is you put the question to me when I made the application earlier to say, are issues not of the national carrier something of the public interest? That was the question to me.
Well, that is a question that a court should rightfully ask.
Yes, my lady, and that's what I'm saying to you.
Or are you suggesting that the court is not entitled to ask these questions?
No, I'm not saying that. And the point I'm saying to you, my lady, I've been saying parties can't come to court and then just raise issues which are hot issues in society and say, this is the national carrier. And by virtue of saying that only, then enter into the realm of acting in the public interest. We cannot just come to court and say, ESCOM, and then suddenly it's a public interest. We need to say more than that. And that's why we said when we start unpacking what the cases are about and what the merits are about, they don't raise a public interest issue, they raise private interest issues happening at SAA. But it's not a bona fide submission to say, by Outa, for Outa to say, they come here in the public interest. My lady, we do not agree. But that as it may be, if the court grants them standing, we remain at this point. The Companies Act is specific. And like it says here, Part B, rights to specific remedies. That whole section, 160 to 165, not a single word there says public interest. But if you come from 156 to 159, it mentions public interest more than 3 times. What is it saying? It's saying at 156, people may enforce certain rights. Rights may be enforced. And we say the rights that they seek to enforce here are not rights covered under 156 all the way to 159. And it's a misapplication of the section. And what vindicates us is the fact that all actions against directors are consistently excluding public interest participation. It's not only 162, it's 69, it's 71. Dismissal of directors. Dismissal of directors may not be done in the public interest. And it says specific provisions. We've got to abide by the specific provisions. And the way to properly apply public interest is to do the following. If the parties conferred with by legislation with the standing to enforce those rights are failing, then it gives rise to public interest. But where people who've got the powers to act for themselves are already acting for themselves, there's no need to burden the legal system with additional litigants. Absolutely none. Because it creates this problem. Your ladyship must now be sitting with an additional 2-3 hours to write a judgment addressing the issue of standing in the public interest when it's not necessary, when there's a party here who's got standing in terms of 1622. Why must we use up more of the court's resources trying to accommodate Outa? Why must we use up more of your ladyship's time to go write this judgment accommodating Outa?
This court was appointed to determine disputes, so that is the duty of this presiding judge to do just that.
And that's my point, my lady. We'd like you to determine relevant disputes. Not parties who are forcing themselves into litigation when they shouldn't be. In fact, they should withdraw, my lady, because the pilots have standing. For this case to proceed, they should actually just withdraw, narrow down the issues in the point, because what purpose does it serve to have Outa here? The pilots have standing, same attorneys, same counsel. In fact, they must just tender a cost of withdrawal and withdraw money.
Well, this is a double-edged sword. You know that, Mr. Buthelezi. On the other hand, if if I play devil's advocate, I could argue, but why are you protesting? It's the same counsel, the same attorneys.
No, my lady, I'm just trying to thin us out in court, my lady. I accept that point. And then, my lady, I'll get to the point of cause. I think I'll raise this point, my lady. They count costs in 4 instances. I think that's not correct. I think the costs can only be applicable to the 2 applications that were brought, joinder and the amendments. But I don't think...
What about the postponement? It stood down for days on end.
That's not related to the application, my lady.
No, it is related to the application. Well, it's related to the time that was spent in the court.
Well, my lady, when we raised the issue of amendments and interlocutories, Rule 28.4, when they objected to the amendments, rightfully so, they themselves are party to the extension of the timelines.
No, but if we look at the postponement, it was directly related to the fact that the defendant delayed her amendments, and that resulted in court time being wasted. If these amendments were brought, if these applications were brought, well, the plea was filed in 2017. If that was brought timeously, then we wouldn't have wasted that time. And I still have to determine the costs involved regarding the postponement.
My lady, I wouldn't want to bang on the drum too much. You ladies made yourself, you've ruled on the point. But in as far as the costs regarding that point are concerned, is that as the new counsel who came on and looked with a fresh pair of eyes.
See, I realize that, but the authorities say even if it's an act of God that causes a postponement, the party who asks for the postponement should, unless there are exceptional circumstances, be obliged to pay the costs.
And my lady, we're not objecting to that authority. We're just saying nothing necessitates that those costs be taxed now. And let's run with the case, and we'll have those costs and costs in the cause, my lady. I don't think there's exceptional circumstances on the part of the plaintiff, so any of the parties in this case, that warrant that the court order that these costs be taxed now, my lady. No further submission.
Thank you, Mr. Buthelezi.
My lady, I'm sorry. There were submissions that weren't made on the papers or in
Yes.
the opening, and the court should please advise as to whether I need to respond to them. And those submissions were that the causes of action, that the transactions in themselves have no public interest. The BNP deal, the Airbus, the Emirates.
Is your submission going to be that those transactions dealt with SAA and therefore
But they're not mere commercial transactions.
they're not mere commercial transactions?
And I hadn't, that was raised in reply for the very first time.
Yes.
The interpretation. Mr. Buthelezi interpreted our
I will
pleadings.
take a look at what was said in the particulars of claim, and I take cognizance of what you are saying.
As the court pleases.
This court will give judgment in this matter at 10 o'clock on the 12th of December. So I'll reserve judgment until then. And can I just request counsel to and the attorneys to quickly come and see me in my chambers? I just want to do some housekeeping. Court will adjourn.